Okay, so this is the deputy convener for the IMAIL, Mridutpal Bhattacharya, and we are gathered here today for match number 13B, which is the semi-final for the IMAIL. This is our first moot, and a first moot organized by us, and we do hope that it goes great. So, without further ado, let's start this session with the permission of Mr. Arbitrators. Let's do start this session. Thank you.
I just had one question for the moderator. Can we tell the time distribution before so that you can intimate us for the timings?
Absolutely, please do.
Yeah, so 20 minutes will be taken by speaker one, 15 minutes will be taken by speaker two, and 10 minutes can be kept for rebuttal. Okay. So may it please the court, the counsel seeks permission to approach the dais.
You may, yeah.
May it please the court, the counsel seeks permission to address the bench collectively as respected arbitrators.
Thank you. Yes.
May it please respected arbitrators, I, counsel one, along with my co-counsel, appear on the behalf of the claimant in the matter of Avron Group versus Government of India. May it please respected arbitrators, I, speaker one, intend to address on the first, second, and third issues, and my learned friend, speaker two, shall address issue 4 and 5 of the appeal. As the honorable bench is well aware of the facts of the case, the counsel seeks permission to proceed with the issues.
Please go ahead. Yes. If that's okay with Paul.
Yes. Thank you. Yes, we've read the facts, I think.
The statement of jurisdiction, the claimant has evoked the jurisdiction of the honorable institution to hear the instant appeal as specified under Article 8.7 of the Bilateral Investment Treaty by virtue of Article 25 of ICSID Convention Regulations and Rule, which states the jurisdiction of the center shall extend to any legal dispute arising directly out of an investment between a contracting state and a national of another contracting state, which the parties to the dispute consent in writing to submit to the center. When the parties had given their consent, no party shall withdraw the consent unilaterally. From now, I'll be proceeding with my issue one. It is humbly submitted to the honorable institution that there has been a violation of the bilateral investment treaty from the side of respondents, and therefore the claimant has approached the ICSID regarding the underlying contract of the bilateral investment treaty. The claimant was awarded the tender of the delivery of 100 artificially intelligent UAVs, which was to be delivered in as per 4 tranches through a blockchain-enabled smart contract, which was availed from a company called Anubandh. And upon the payment of each tranche, 25 vehicles will be delivered. The first payment was done as per the contract in June 2023. The second payment, which had to be done in December 2023, was defaulted by the respondent. In December 2023, the tranche payment did not take place due to an error in the blockchain-enabled smart contract, which was provided by a Windavian-based company, Anubandh. Later on inquiry, due to the default in payment, it was found out there was a misrepresentation from the part of Anubandh that was blockchain technology being used by Anubandh for their smart contract was being tested under a regulatory sandbox framework where similar blockchain technologies were being tested. This certain fact was concealed by the Avron Group respected arbitrators, I would like to state. Further, the respondent did not pay for the second tranche even after being requested by the claimant and by claiming that they are obliged to pay through any other method that can one contract upon, as there was no safety clause provided to us. Later on, the claimant also gave out the information that the respondent has sent the UAVs to an indigenous company, which is against Article 1, Clause 1.1, that lays down that the confidential information in the business and exchange had to be kept, which was violated by the respondents when the respondents approached and dispatched the UAVs to an indigenous company for inspections relating to default in algorithmic camouflage and landing trajectory. This certain action by the respondents has violated the confidentiality clause of the Avron Group for their aerial vehicles. This could have been seen as a breach of Article 1, Clause 1.4, subsection F of the Bilateral Investment Treaty talks about copyrights and intellectual property rights, etc., which of the claimant has been exposed to other companies by the respondent as the claimant owns the patent of the UAVs. It can also be uh, it can also be insane there was a breach of contract as per Section 73 of the Indian Contract Act, which could be seen as the material Section 54 of the ICA talks about effect of default as a promise which could be first performed in contracting consists of reciprocal promises relating to this section. Manufacturing and delivery of the third consignment was not done due to the default of payment by the respondent. And I would like to mention respected arbitrators. As per Article 3, Clause 3.2, the petitioner had already asked for civil remedies regarding the breach of contract in domestic courts, but no action was taken for the same. And due to inaction after 1 year, the notice of arbitration was served to the respondent. Respected arbitrators, may I refer to the case Tokyo Stolkis versus Ukraine, which was of the same tribunal. The jurisdiction decision of a company was looked into, and also through this, we can understand the arts in the bilateral investment treaty also is important when it comes to jurisdiction and court to approach. Jurisdiction is also determined through Article 15 of the ICSID Convention while relating it with the followed bilateral investment treaty. As the claimant company's origin is from FIRL, as per 25, the ICSID can be approached by the claimant. And may I refer to another judgment, SGS Solitaire General D Surveillance SAV versus the Republic of Philippines and the Rome Petrol Group Romania, which states the same. It has been provided to you in the memo, page number 16. You can refer that. And even the White Industries Australia Limited and Republic of India, it was distinguished that the substantive requirement to exhaust local remedies for breach of effective means standard to be completed from the strict prior exhaustion requirement applied to the denial of justice. The tribunal stated the former is a qualified requirement for exhaustion of local remedies. This approach is followed by this tribunal. As per the petitioner had waited and completed all the clauses according to Article 8 mentioned in the bilateral investment treaty for the settlements of dispute, this cause of action should be before the International Center for Settlement of Investment Disputes, which has been arisen due to underlying contract of BIT. Hence, we submit there has been a violation of bilateral investment treaty from the side of respondent, and therefore the claimant has approached ICSID regarding the underlying contract of the BIT. If the respected arbitrators don't have any queries, the council seeks permission to move to issue 2.
Just a quick one, if I may, because it's going to come up with the respondents. This argument that we're really dealing with a straight breach of contract claim, which ought to be pursued through the civil courts. Could you just expand for me, please, your thinking on why that is not the case and why Article 25 of the ICSID Convention applies?
Yes, indeed, respected arbitrator. I would like to mention again that if the case Tokyos and Tokles versus Ukraine, and we are an investor, and I would like to mention it is a foreign direct investment, and the main purpose of the special economic zone where our company is located is to enhance the foreign direct investment. There are investors, as per the enterprise definition in the bilateral investment treaty, it has been established in BIT 1.4 through the facts it has been established till now that they are investors. And since I had referred to the case Tokyo Stockless versus Ukraine, which is of the same tribunal, they stated the jurisdiction decision of a company was looked into, and also through this we can understand that the articles in the BIT also is important when it comes to jurisdiction and court to approach. Jurisdiction is also determined through Article 25 of ICSID Convention, which I mentioned in my jurisdiction statement. I believe I have cleared your doubt, respected arbitrator.
Thank you. Yes.
Moving forward with the issue 2, it is humbly submitted to the honorable institution that there has been a violation of the doctrine of protection and security, that is Article 3 of the BIT has been violated by the respondents. There is a violation of Article 3 of BIT, where complete protection and security had to be provided by the government when the protest took place. Section 56 of Indian Contract Act gives us the clause of force majeure and doctrine of frustration of contract, for which the courts have interchangeably used the terms frustration and impossibility to perform. In the case of Satyabha Bose versus Munira Bangor and Company, the defendant company promised to sell the plaintiff a plot of land after developing it by constructing the roads and drains. However, some portion of the area included in the scheme was requisitioned for military purpose. The Supreme Court, while applying the doctrine, held that the area had not sustainably prevented the performance of the contract as a whole, and therefore the contract had not become impossible within the meaning of Section 56. No matter what event took place, it was the responsibility of the government to provide the needed protection and security to the claimant and their investments situated in the country. And it was also the duty of the respondent to maintain the public order and public morals as per Article 10 clause, because it was not maintained by respondents as civil unrest and violent protests took place. In such a scenario, it was the responsibility of the respondent to take precautions and provide full security and protection. But as they have failed to do, they are responsible to pay the damages done to the investment, the branch office of the claimant done by the claimant. The respondent should have taken needed precautions given into the notice of the respondents that there was a civil unrest and violent protest due to the bill introduced. Respected arbitrators, I would like you to mention the case Pachinki SA Contractors and Engineers versus the Republic of Albania, argued that Albanian authorities did not protect the claimant construction project and failed to provide full protection and security. The tribunal held that the Albanian authorities were powerless and the police were simply unable to prevent the losses under the circumstances of the case. Furthermore, the tribunal held that arbitrators must consider the circumstances and resources at the disposal of the relevant state and thereby consider the state level of development and stability. Therefore, it was the responsibility of the respondent to provide the claimant full protection and security as per the bilateral investment treaty. If any losses are incurred, the same has to be compensated, which will be argued by my co-counsel. If the respected arbitrators do not have any queries, I would like to seek permission to move to issue 3.
Just one quick question, if I may. This obligation of providing protection and security cannot be an absolute one, right? It has to be on the standard of due diligence and the state doing whatever that it could. Do you think exercising due diligence by itself is good enough as the respondent's claim? And second is, how are they not entitled to the defense of force majeure here?
Indeed. Indeed, your respected arbitrator. I would like to mention a condition which happened in China. There were protests taken because of the same policy applied to China. So the Windavian government could have understand they have applied that policy and there could be a civil unrest. So it could be foreseen. Therefore, they cannot use the defense force majeure in this. Plus, it was bill unrest was foreseen. If you would have understood this example, you could have understood my point, my claimant's point, that this protest was foreseen by the Windavian government as they had seen it in China, and they could have relied upon China and protected and given security to the claimant. Respected
Go ahead.
arbitrators, I believe I have cleared your confusion.
Please go
Or
ahead. Thank you.
yeah,
I'll just step in there if I may. Thank you. The case law says that civil unrest and similar circumstances are often not sufficient or don't fall under due diligence, as my colleague has said. So what in particular are you relying upon here? I know you are referencing the Chinese example, but what are you particularly relying on here to say that this is not a normal civil unrest case, which would typically be unforeseeable and therefore not a breach of the protection and security provisions? I just want to get that clear, thank you, because it's quite important.
yes. Indeed, respected arbitrator, it was a pertinent observation of you. I would like to state that China implemented the same policy. That's why I was relying on that policy, because they knew of they have implied such a huge bill to the country. There could have been a civil unrest, the same like China. So they could have been well prepared for the civil unrest, and it was predictable because the world has seen one of them. They should have been well prepared for it. And it can be predicted and it can be foreseen because of implementing such a policy at a huge scale. The unrest could have been taking place.
Thank you.
Respected arbitrators, I believe I have cleared your query.
You may go
The
ahead, please.
council
Thank you.
seeks. Okay. It is humbly submitted to the honorable institution there has been a breach in the confidentiality clause of the bilateral investment treaty, as the respondent has dispatched few of the UAVs to an indigenous company, respected arbitrators. Confidentiality clause being a non-disclosure clause that has no information regarding the contract or the products delivered in the contract be shared with a third party other than the claimant and the respondent, unless provided so in the contract, cannot give the UAVs to an indigenous company. It is also being clearly laid out in Article 1, Clause 1.1 regarding business confidential information which has been violated by the claimant. There has been exposure of Clause 1.4, subsection F, as the claimant owns a patent under the PCT process of artificially intelligent UAVs in FEREL and also claims its benefits successfully for the same in the respondent territory. The confidentiality clause has been reached as per Section 73 of the ICA, and claims are responsible to receive any losses received from such breach. There has been a breach of Article 7 of the Bilateral Investment Treaty. It has been clearly mentioned under Clause 7.2. Therefore, any kind of measure which was taken by either of the parties is out of contract. It has to be consulted to the respective parties, and their opinions and perspectives has to be taken into account before a certain measure is implemented. According to it, respondents should have at least been informed before UAVs were dispatched to a third party, and the respondent should have consulted with the claimant. Further, should have adopted a measure which was agreed by both the parties, but no discussion or negotiation took place. Neither did the respondent consider it, which is clear breach of contract. And I would like to mention the product information has also been shared by the UAVs being dispatched to an indigenous companies. This softwares, technologies, hardware, all this information will be exposed to the third party, which is a clear violation of these clause. The use of algorithmic camouflage is mainly for visual detection and targeting after the visual is gained. Countermeasure is an action which is taken to a counter a certain other action security and safety person. It could be active or passive, or is a protection measure especially used in military. It is used for developing missiles, and the military exploits all the available technologies for the same purpose. Respected arbitrators, I would like to mention the case Murphy versus Chestnut Mountain Lodge Incorporation and Swarovski versus the Universal Marion Corporation, which is in our submissions, page 20. It was said that the technological possibility, but also the present state of the art, therefore, all the possibilities cannot be looked into, especially all the technological advancement, level of pertinent scientific and technical knowledge existing at that time of a product's manufacture, and the best technology reasonably available at that time the product was sold. The fact that the claimant understands the above mentioned statement that algorithmic camouflage was indeed countermeasure technology because of the use of algorithmic camouflage in the tanks, the detection, it was not possible by the UAVs, which led to the crash of UAVs in the tank. The miscalculation of the landing trajectory was due to algorithmic camouflage used by the military tanks, which made it impossible for the UAVs to get a visual representation. Therefore, after sale services are not necessarily provided. Hence, there has been a breach in confidentiality clause of the bilateral investment treaty, as the respondent has dispatched few of the UAVs to an indigenous company. If the respected arbitrators do not have any query, I would like to call upon my co-counsel for moving forward with the issue 4 and 5.
Just one, if I may, before we move on. Paragraph 2 of your
Indeed.
section dealing with confidentiality, which I think is on page 19, you talk about the claimants are responsible to receive any losses from the breach. It's not clear to me what losses you are seeking in relation to the alleged breach of confidentiality. I appreciate your friend may be dealing with this point, but could you just point me in the direction of what losses you are claiming for the alleged breach of this particular provision?
Indeed, respected arbitrator, pertinent inquiry. I would like to mention that I have mentioned in my argument the softwares, technology, hardwares, etc. All this information will be exposed to a third party, which is a competitor to us, and they can take away the technology and produce the same product, which will cause us losses and the copyright benefits we hold. Because we have argued one clause 1.1 where owns the patent of PCT and also claim the benefits successfully for the same in the respondent territory. So all the benefits we hold can be considered under the damages we are claiming for. Furthermore, my co-counsel will explain it to you. I believe I have cleared your queries.
Oh, look, I'll hear from your co-counsel on that point. Thank you.
Indeed.
Respected arbitrator, am I audible?
Yes, you are. Yeah.
Respected arbitrator, if you have no clarifications in the beginning itself, I would like to start with issue number 4.
Thank you. Yes.
The council pleads to the tribunal that the claimant, that is the Aviron Group, shall be redressed for the violation of the principle of national treatment and the breach of legitimate expectations on the fair and equitable standards in respect of a differential treatment in the imposition of the IGST. Respected arbitrators, my client was slapped with uncalled for hefty tax bills, even though my client applied under the Make in Vindivya scheme, which provides that a tax exemption should stand. My client also set up an Indian subsidiary in the special economic zone, which thereby falls under the category of the tax exemption also. To import, specifically in regards to imports relating to defense and internal security forces as received by indigenous producers. Anything related to taxes for a company falling under the special economic zones is dealt under Section 3, Subclause 7 of the Custom Tariff Act as per the Taxation Law Amendment Act 2017. There was a notification by the end of the government dated 18th May 2017, number GSR article number 291 subclause E. It read that in exercise of a power conferred by subsection 1 of section 25 of the Customs Act, the central government being satisfied that it is necessary in public interest so to do, exempt goods falling within the first schedule of the Custom Tariff Act when imported into Vindivya from the whole of the duty of the customs levied thereon, which is specified in the first schedule, and from the whole of the additional duty levied thereon under Section 3 of the second mentioned Act. The goods imported fall under this schedule as this import is generated out of a tender by the Ministry of the Defense, and therefore the IGST cannot be claimed. Additionally, the national treatment, that is treating both foreign manufacturers, investors, and local producers equally and giving them equal opportunities and tax benefits. In this scenario, where my client, the Aviron Group, was employed under the Make in Vindivya scheme, and therefore and their counterparts, the competitor indigenous companies, were employed under the Vindivya Nir Bharat scheme. Both the schemes had similar tax exemptions, but yet this exemption was revoked for my client and not not for the indigenous companies, establishing the predominance of an unfair treatment and the violation of the principle of national treatment. Article 4, additionally, of the Bilateral Investment Treaty states that the party shall not apply measures that accord less favorably in less favorable treatment to other parties than it accords in like circumstances to its own investors. In this scenario, all the situations are similar. Both the schemes run in a similar way. The only difference is that in Make in Vindivya scheme, these are foreigners, and Vindivya Nir Bharat scheme, it is an in-house producer. Rest all the other articles of the scheme are very similar. Yet there was a difference in the way it was treated. Respected arbitrator, isn't that a clear violation of the principle of the national treatment? Additionally, when we talk about the General Agreement on Tariff and Trade Act, Article 3 requires that the host country provides for proper implication of the principle of national treatment. Not just this, respected arbitrator, Article 3, subclause 1 stipulates the general principle that the members of the World Trade Organization must not apply internal taxes or other internal charges, laws, regulations, and requirements affecting imported or domestic products so as to afford protection to domestic production. And as we all know, Vindivya is a part of the World Trade Organization. Article 17 of the GATS and the Article 3 of the TRIPS also validates the same. The same can be understood by a case of this respected tribunal, Anchor Denius, Minland Company, and Tate and Linland Ingredients America Incorporated versus Mexico, a case of 2007 of the same tribunal. The objective of this article in this case is to ensure that the national measures does not upset the competitive relationship between domestic and foreign investors. Under the national treatment, obligation occurs when foreign investors have unreasonably been treated less favorably than the domestic investors, which is a case in this scenario. The tribunal concluded that the tax treatment by the government of Mexico was discriminatory and amounted to a breach of the national treatment obligation. The same can be further read in the memorial under issue number 4. And additionally, as we talk about this, national treatment can also be understood as fair and equitable treatment. This can be understood with the case of Shukla Investment versus Seasoned Republic. The tribunal observed in this case the ordinary meaning of fair and equitable treatment. Standards can only be defined by the term of almost equal weakness. The measures adopted by the host are against the minimum international standards required by the customary international law, as well as the law mentioned previously by myself as my co-counsel. Furthermore, if moving forward to the doctrine of legitimate expectations, that is expectation of a benefit, relief, or a remedy that may ordinarily flow from a promise or established practice, not be based on the strength or an act imposed internally. The same can in support of this submission, we rely on the case of Ram Parvesh Singh and others versus the state of Bihar, a case back in 2006, which stated that the expectant must be entitled to the relief of an opportunity to show cause before this expectation is dashed. And in the case of the Allen Jean and other versus Willington Flex and other, the tribunal's case itself, wherein and whereunder, taking aid from a decision rendered by Lord Denning LJ in Parker versus Parker, extended the scope and applicability of this doctrine of legitimate expectations, even to the domain of private contract law. It read, in the same judgment, the judgment read, the courts of the 21st century cannot be denied justice to anyone for a lack of precedents or a lack of case laws in a particular branch of jurisprudence due to the stagnancy and adaptation and advancement. We cannot afford our civil law to remain stagnant in the statutes and books simply because a jurisprudence is not advancing with the rest of the legal world. As judges, we cannot simply fold our hands on this bench to say that no case has been found in which it has been done before on the grounds of legitimate expectation in contract law. therefore applying that the legitimate expectation will now thereon also be applied in the contract law. The same can also be understood by a case that is from the Honorable Patna High Court, that is the State Bank of India and another versus MS Sington Roller Floor Mill, and the similar contentions were upheld in this case by the tribunal in the case of Patrick versus Patrick, as I already mentioned, and the Anchor Daniel case versus the state of Mexico. And all of this so far so spoken being supported by the article number 6 defined under article 1 subclause 1 and article number 4 of the bilateral investment treaty as presented in the fact sheet. If my respected arbitrators do not have any questions, the council would like to seek permission to move forward with the issue number 5.
If I may, yeah, just a quick one there. Don't you think that the expression fair and equitable treatment was consciously avoided, and that wasn't a guarantee that was ever given to you as an investor?
Um, Sir, in regards to the fair and equitable treatment, just a minute. Sir, when we talk about fair and equitable treatment, it was a part of the bilateral investment treaty. Fair and equitable treatment is also upheld in all the case laws and the things and the statutes that I've previously spoken. Even if it was not a part of, in a hypothetical scenario, if it was not a part of the bilateral investment treaty, it should still be applied because keeping in mind the international standards of arbitration and the basic terms of goodwill, modesty, and justice.
Understood. Just a quick question on legitimate expectations. When you were making this investment, were you relying on that expectation in the first place? Because I believe that's a necessary precondition for you to uh, make an argument on legitimate expectations. Was it in your contemplation that this is how the things are going to be, and did you make the investment relying on that assumption of yours?
uh, when we talk about legitimate expectations, just to clarify on that, we talk about a lot of things. Now, legitimate expectation starts initially from um, the basic thing that at least when they wanted to exempt us from the IGST that they were implying, which is clearly unfavorable, we should have been informed about it before the enhancement of the contract or before the deal was signed, that this tax exemption is only going to be applied for a certain amount of time. But these are the basic things, which in regards to which the party expects. Now this is only being clearly not upheld. It is also a consolation of facts if we talk about it like that. And when we talk about legitimate expectations per se, it is basically as in other cases that I've already spoken, specifying the Ram Prakash Singh case versus the state of Bihar, a 2006 case. It is important for the party to be known what is the, at least, to be receiving a show cause notice before any of these expectations that are reasonable be dashed. And how do I categorize these expectations as reasonable is because they fall under the general international framework and general international standard, also supported under the BIT.
Thank you.
If the respected arbitrators do not have any further questions, the council likes to seek permission for moving forward with the issue number 5.
Yes, please.
Thank you. My client is entitled to the damages of US $670 million and the cost of the entire arbitration proceedings using the method as established under the case of MC Dormant International Incorporated versus the Burn Standard Co. Limited case, along with the Glanlet Construction Company case. Using this method, we can calculate the damages suffered along with the amount of projected loss in revenue because of the revocation of IGST exemption that amounts to US $70 million, 2019, making a total up of US dollar 670 million and the cost of the entire arbitration, also supported by the latter part of article number 11 under the BIT. To understand the same, we can refer to a set of cases of this tribunal, such as the Norway Solas Construction Company Limited case, the Beechwood Development Company case, the Harvey Shoplifter case. These are all examples of the similar situations wherein the same was upheld. Article number 3, subclause 1, that talks about full protection and security, as already mentioned, states that each party shall accord in its territory to investment of another party and to investor with respect to their investment full protection and security. For greater certainty, full protection refers to parties' obligation relating to physical security of investors and to investment made by the investor or of the party, and not to the other obligations whatsoever. Additionally, Article 4 of the Bilateral Investment Treaty has also been breached along with Article number 3, subclause 1, as stated. To support this argument, we would like to refer to the case of Shukla Investment versus She's Republic, and the case of BG Group versus Argentina, and the case of Eastern Sugar versus She's Republic. Of this respected tribunal stated that the full protection and security standards apply essentially when foreign investments have been affected by civil strife or physical violence. The state of Vindivia also witnessed a civil unrest and the violent protest owning up to the population control bill, and hence it is an obligation of the government of Vindivia to extend its protection to all affected entities, as it is doing for the indigenous companies, again, when we talk about the national treatment point. The regulatory framework was in notice of the government, and that it was not informed. When we talk about additionally, a breach caused by the company Anubandh, that was an entity under the regulatory framework of the government of India, who concealed a fact that it was being tested under the regulatory framework. It was the responsibility of the host country itself, as it is testing this specific institution, to inform us, as it was a 50-50% decision in regards to employing this company for the provisions of the blockchain. So in simple terms, the amount of 670 US dollar can be broken up into various categories, essentializing the loss suffered by the civil unrest, taking into account including all other damages suffered to the building and other physical and personal damages incurred due to the breach of the contract by the government of Vindivia and the company Anubandh in also confidentiality breach, and all issues already mentioned in the arguments and the submissions put forth by myself and my co-counsel. If your respected arbitrators do not have any further questions, this is where we rest our case.
Just one, if I may, and it's the same point I put to your co-counsel around breach of confidence. Am I right in thinking that that's an anticipated breach? What I mean by that is that there is no evidence of any losses suffered to date. Is that the way I should be looking at that cause of action?
Respected arbitrator, the physical damages that you're referring to are provided under the fact sheet. It can be referred to in the same around, if I'm not wrong, around paragraph number 4 or 5. It's
Thank you. I'll have a look there. I'm conscious of time. Thank you.
Thank you.
Good morning. Do I have leave to begin? Thank you.
Yes, please.
Before I start my timer, I'll explain the split up that my co-counsel and I have agreed to. I will be taking the first 18 minutes to address the first two issues, and my co-counsel will take 22 minutes to address the remaining issues, and whatever time remains will be allotted to rebuttal. All right. I shall start my timer now. Members of the tribunal, on behalf of the respondent in today's proceedings, that is the state of Vindhya, my co-counsel and I raise 5 issues that have been listed for the hearing. Of these, I will be addressing the first 2. The first issue that has been listed today and was brought up by the claimant is with respect to the Aviron Group's cause of action before this tribunal. In this regard, they correctly pointed out that Article 25 of the Exit Convention applies here, given that this tribunal was established under the convention. If I may reiterate the provision under Article 25, we see that the jurisdiction of the center, and by extension the jurisdiction of this tribunal, has been restricted to legal disputes that arise directly out of investments. This means that for the claimant's case to be admissible today, it needs to be pertaining to the claimant's rights as an investor under the BIT. In the present case, however, of the 3 substantive issues that the claimant has raised today, not one falls under the scope of the rights that are protected under the BIT. In order to establish my point, I will address each of the issues that they have brought up today and talk about why it is not maintainable before this tribunal. Make is with respect to the damage to property at Mechley. As they correctly point out, Article 3.1 creates an obligation on the state to ensure full protection and security of investments and investors in relation to their investments. In the present case, members of the tribunal, there exist 2 distinct legal entities. First is the claimant, that is the Aviron Group that hails from Firel. And the second is the enterprise that it has established under the BIT in the Special Economic Zone. The investor had a branch office in the capital city of Mechley, and that was a representative office that does not form a part of the investment. In fact, given that it was a branch office of the Aviron Group, it was established to cater to all the needs of the Aviron Group, including but not limited to its obligations or its rights under the investment. This means that as a representative office, it forms a part of the legal entity that is the investor and not necessarily only in relation to the investment. In this case, therefore, the property that was damaged at Mechley is not protected under this BIT, and any damage that occurred to it must be taken up before an appropriate domestic tribunal and not this tribunal. The second issue pertaining to this dispute that the claimant raises is with respect to, firstly, countermeasure technology and whether algorithmic camouflage counts as countermeasure technology against a UAV. With respect to this particular issue, members of the tribunal, the outcome of a decision on this question will only decide whether the respondent has access to after-sales services or not. This means that it is a purely contractual commercial question. In the case of Toto Construzioni versus Lebanon, an exit tribunal just like this one laid down a test to decide whether a claim was contract-based or treaty-based. In order to make this decision, it said, you must ask yourself if the actions of the party were performed in its capacity as a party to a contract or in its capacity as a public authority. In this case, we see the provision of after-sales services purely pertains to the respondent's relationship with the claimant with respect to after-sales services, which is purely contractual in nature. Similarly, the second part of this issue that they raise with respect to the alleged breach of confidentiality, this too is not covered under the rights that are guaranteed under the treaty because the actions that were taken by the respondent in this case were in its role as a commercial player. One of the UAVs was not working. The original seller refused to grant any manner of assistance, and so they went to the nearest person who can find the defect and repair it. This is not an act it did in its capacity as a public authority, and therefore this does not constitute an investment dispute. The third issue that they raised today is with respect to the differential taxation. However, members of the tribunal, I would like to direct your attention to page number 16 of the record. Therein, at the very top of the page, we say, under Article 2.3, claims arising out of events which occurred prior to the entry into force of this treaty have been categorically excluded from the ambit of the treaty. This means that given that the withdrawal was a decision that was made before the treaty was even entered into, all the way back in 2019, whereas the BIT was entered into only in 2022, the exemption was it was decided that the exemption would only last till 2023, and therefore the claimant could not have expected that this would not change. In the absence of a stabilization clause, such an expectation is completely unwarranted and does not stem from any of its rights under the BIT. Given that this is also outside the scope of the rights protected under the BIT, this issue too is not admissible. For these reasons, yes,
Sorry,
Mr.
sorry to interrupt your flow there, but would you accept though that the actions? I appreciate what your argument is regarding the tax. I understand that, but would you accept that the actions of your client in that instance are at least the actions of a public authority, and if we find that the representation about the tax coming off at the end of 2023 is not binding on us, would you accept that that brings the tax question at least into our jurisdiction under the BIT?
Mr. Arbitrator, in the present case, the BIT itself specifies that events that occurred prior to the entry into force of the BIT are not within the scope of the BIT. This means that any rights that emanated from such an event pre-existing the BIT do not hold any effect with respect to the BIT, because that was something that was established later. We also see that there are several authorities in international law that support this proposition that would strongly be against any decision you make to admit this particular issue. For instance, the International Law Commission's draft articles on responsibility of states for internationally wrongful acts under Article 13 explicitly states that there cannot be a breach of an international obligation unless the state is bound by that obligation at the time that the event occurred. So, with all due respect, Mr. Arbitrator, you do not have the jurisdiction to admit this issue. However, even if you do believe that this particular issue and all others are admissible in this case, my co-counsel and I will show you that these issues do not hold any substantive merit either. With that, I will now lead you to the second issue that the claimant has
I'm
brought
so
up.
sorry. Before you do that, what was the date of this notification, if I may ask? I missed that.
Uh,
You were saying
Mr.
this was prior to the BIT.
Absolutely. This particular notification was made in 2019. If I may direct your attention to page number 7 of the moot proposition,
Mm-hmm.
at the very last line of, at the very last sentence of this particular page, we see that the exemption, the exemption notification clearly stated that the tenure of the exemption would be from 2019 to 2023. So the time period for this particular exemption was something that was decided at a time before the BIT even came into existence.
I'm not sure of that. That's the reason I ask you the date, because this can also be retrospectively applicable, right?
Mr. Arbitrator, while it is true that under ordinary circumstances this may be retrospectively applicable, in this
Mm-hmm.
case, under Article 2.3 of the BIT, it's been specifically stated that causes of action that arise out of events that precede the entry into force of this treaty are not within the scope of the treaty. So it excludes any such event that predates the entry into force of the bilateral investment treaty.
Understood. I'm just saying this because you obviously have mastered the facts. I wasn't sure that this notification actually got promulgated before the BIT or not. That was solely the question.
Mr. Arbitrator, we're also constrained by the amount of detail about these facts.
Hmm.
So even if you are not convinced with the non-maintainability of these issues, we are ready to show you that none of the substantive issues raised by the claimant in fact hold any water.
Please
In this
proceed. Yeah,
regard,
thank you.
thank you, Mr. Arbitrator. In this regard, I would like to address the second issue that was addressed today with respect to the damage to property in Mechley. Even if we consider that the branch office is in fact a part of the investment, we need to look at the nature of the responsibility that the respondent had under the BIT. In this regard, the full protection and security standard, as it is internationally recognized and applied, has two primary aspects to remember. Firstly, that the government in this case and in every other case only has an obligation of due diligence, as Mr. Arbitrator correctly pointed out. And secondly, the force majeure exception applies in the present case. I will establish each of these two assertions I just made. Firstly, I would like to call back a certain case that the opposing counsel had raised, a case that pertained to an investment set in the country of Albania. To add to that case, let me introduce two more cases. Firstly, the case of AAPL versus Sri Lanka, and secondly, the case of AMT versus Zaire. What is common between these three cases and is that they are all different in their material facts from the present case. This is because all the countries where these investments were countries that were already prone to civil strife and were war torn in some way or the other. There was already a lot of violence that was ongoing in these places when the damage to property occurred. And in these cases, the tribunal very correctly found that the force majeure exception cannot apply. However, in these cases, it was also observed that the government only has a duty of due diligence and has no strict or absolute liability to prevent any such damage from occurring. And in addition to that, with respect to the force majeure clause, we see that under the BIT, Article 1.3 includes man made events into the definition of force majeure. And it also states that a force majeure event is one that is unforeseeable and uncontrollable in some way. In the present case, also, we see that a certain population control bill was merely introduced in Parliament. This is evidenced from paragraph number 6 on page number 5. We see that the bill was only introduced. In a country like Vindhava, which is pari materia to India, democracy prevails, and because of that, parliamentary discussions are bound to include controversial topics. Controversial topics are brought up on many occasions, and with respect to this particular population control bill, I would like to draw your attention to the fact that there was a similar population control bill that was very recently introduced by the government of Uttar Pradesh. One aspect that was introduced in this particular regard was that a public platform was created by the government to accept public comments, criticisms, and suggestions about the bill. The government of Vindhava constantly creates these platforms for peaceful protest, which is a constitutionally guaranteed right, and for such platforms where the people can communicate with the government with regard to their grievances from a bill. There are several protests that happen on a regular basis through all parts of Vindhava. However, that a protest would go out of hand and become violent is not something that can be reasonably expected from a country that is not constantly war torn. A country that experiences relative peace need not constantly stay on high alert with almost paranoid tension that some sort of violence is going to break out in the streets. Therefore, the obligation, the due diligence that the government had to perform was far lower than in other cases where such incidents happen more regularly. In this regard, I would also like to mention that there have been several other times where a certain controversial bill was introduced in the parliament or even passed by the parliament, where civil protests and riots actually broke out in India and especially in Delhi. In these cases, it must be remembered that the the initiation of protests is usually always peaceful. In all these cases, all these protests started out as a bunch of people standing on roads with placards, and it was some triggering element that tipped it over. It's never expectable or foreseeable when a peaceful protest will escalate into a civil riot or civil strife. However, it must be remembered that the government cannot permanently remain on high alert in the expectation that something is going to go wrong. For that reason, there was no higher degree of due diligence that the government had to perform than the degree that it did, in fact, fulfill. And therefore, there cannot be any obligation of the claimant that's found under Article 3.1 because the respondent's liability has been exempted under Article 3.3 by virtue of this event being a force majeure event. Um,
Can I just interrupt there? Sorry, because I understand the position from the claimant that they are saying due diligence on this matter would have highlighted the fact that similar legislation in China resulted in significant civil disruption, and therefore your client ought to have built that into its consideration, which brings this matter out of force majeure and into the type of due diligence test that my friend was questioning on before. Interested in your response to that particular point.
Thank you for your question, Mr. Arbitrator. I would really like to address this because the case with the China and the population control bill in this fictional circumstance, the only similarity is that both are population control bills. One is set in China and the other is set in the democratic nation of Vindhya, where peaceful protest is a constitutional right, which means that people have the right to express their dissent in a peaceful manner. Therefore, when people gather and sit around to talk about their views on something in Vindhya, the government need not react as harshly as the government in China would. This is because of the different political atmospheres of the two countries, and that comparison is incorrect. On the other hand, a better comparison, members of the tribunal, would be between other controversial bills that were introduced or passed in India and this particular bill. We see that even with respect to the Citizenship Amendment Act, which escalated into great violence after a point, peaceful protests, had been going on since well before the act was even passed. And these were occurring over a period of time. The same can be said for the farm bills, which also ended up escalating into violence. That initially, all these protests start out as peaceful, and therefore there is no need or no way of ascertaining how or when such a protest would escalate into absolute violence. Uh, because there exists enough democratic methods of redressing these grievances that the public has. For that reason, the breach of the full protection and security clause cannot be found in the present case, and the government of Vindhya cannot be held liable for it. With that, I would like to call on my co-counsel to address the remainder of the issues. I thank you for your time.
A very good morning to the tribunal. I hope I'm audible.
Yeah.
Thank you. Uh, Taking on the dais from my co-counsel, I would be addressing three issues. The first of the three issues being that Aviron Group is not justified in treating algorithmic camouflage as a countermeasure technology, and secondly, that there has been no breach of any confidential information. The second issue that the council would be addressing is with respect to the breaches of the national treatment and the fair and equitable standard. And finally, the respondent, after all these issues, will be arguing as to why there is no compensation that needs to be paid out by the government of Vindhya. With respect to the first issue, that is the treatment of algorithmic camouflage as a countermeasure technology, the first submission with respect to such a treatment is that algorithmic camouflage specifically cannot be treated as a countermeasure technology. For the same, to make these submissions, the Council would like to refer to page number 21 of the submitted memorial, wherein on paragraph 43, a countermeasure technology has been defined. A countermeasure technology is a safeguard prescribed for an information system or an organization designed to protect the confidentiality, integrity, and availability of information to essentially meet a set of defined security requirements. Now, for an artificially intelligent UAV, it has to be fed data to make sure that it can deal with any countermeasure technology, which means that any the that which is the basis of how artificial intelligence works. Artificial intelligence works on the basis of data being fed into the computer system, which is then replicated and stored, and then action is taken further. Now, if now coming to the facts of the current matter, the while testing multiple UAVs, one of such UAVs crashed into a military tank while landing, as the UAV could not identify the presence of algorithmic camouflage. It's very pertinent to note that only one of such UAVs crashed and none of the others crashed. This brings to light the specific issue that if none of the UAVs were equipped to deal with algorithmic camouflage, why did only one of them crash? Therefore, the argument with respect to this issue that the respondent submits is that the UAVs were trained against algorithmic camouflage. They were already fed with such data, ultimately rendering that the algorithmic camouflage cannot be used as a countermeasure technology because it has been already addressed in the artificially intelligent UAVs. Therefore, the UAV that crashed because of a software or a hardware glitch that was covered in the after sales service contract, as has been mentioned in the moot proposition. This is the first argument that the respondent would like to submit with respect to the fact that the treatment of algorithmic camouflage as a countermeasure technology and not providing any after sales services to the government of Windiva was absolutely wrong and a breach of the contract. The second argument with respect to the same issue that the council would like to make is that the UAVs were not fit for the purpose for which machineries of the same description would ordinarily be used. With respect to the same, the council would like to refer to section 16 of the Sale of Goods Act of Windiva, which lays down certain implied conditions as to the quality or fitness of the goods that are being provided. The section clearly states that if there is express or implied clarity given as to the purpose for which the goods are to be used, there is an implied condition that the goods that will be provided by the supplier shall be reasonably fit for such purpose. In the current factual matrix, it was very clearly told to all parties bidding for the tender that the UAVs are to be used for the Air Force. The Air Force, by implication, uses such UAVs either for defense or surveillance purposes, which are the two main purposes that any Air Force uses such UAVs for. Due to technical and software errors, a UAV crashed into a military tank. And there was also no after sales services. Therefore, there was a specifically compromised quality of the UAV that was provided to the respondents. The claimant was well aware of the purpose that was to be used. Hence, the argument that the respondent is making that the UAVs provided to the respondent were not satisfactory for the purpose that they were to be used, and therefore they were in violation of the domestic laws of the state of Windiva and also international laws as is provided under the Uniform Law on the International Sale of Goods. Moving forward, the respondent argues that there
I'm
has
so
been.
sorry if I may just ask a question on the earlier point. So I understand your argument on Section 16 and the sale of goods bit, but what's the sequitur to this? Are you seeking a relief? Is there a counter claim here, or are you just using this to sort of defend the claim of breach of confidentiality? Like, what is the consequence of this argument?
Thank you for the question, Mr. Arbitrator. The respondents believe that the correct forum for all of these arguments is the domestic tribunals and courts in the country of Vindeva, where such arguments have been made and such relief will be sought. However, as has been argued by my co-counsel, this is not the appropriate forum. However, to satisfy the arbitrators, this argument has been made right now.
Thank you.
Much obliged. Moving forward, the baseless claims of the claimants that there has been a breach of confidential information will now be broken down by by the council. The first argument is that a very specific important aspect of international law is with respect to the public interest argument. Now, with respect to sale of goods and confidential information and intellectual property rights, there is the point of honest commercial practices and the public interest at hand. With respect to the same, the council would like to refer to page number 23, paragraph number 54 of the submitted memorial. Under Article 10 of the BIT, it was clearly stated that nothing in the treaty shall be construed to present the adoption or enforcement by a party of measures of general applicability on a non discriminatory basis that are necessary to protect human, animal, or plant life and to protect and conserve the environment, including all natural and non natural resources. Now, why is this being submitted is because we're talking about a malfunctioning UAV. There are multiple things that can go wrong with such a malfunctioning UAV. If the Air Force is using a UAV, it is using it for the purposes of defense and surveillance. Such a UAV being used for the purposes of defense and surveillance needs to be fit for the purpose it is being used. And any measure to get the same UAV corrected or have an after sale service were denied, absolutely denied by the Aviron Group on the baseless claims of it being damaged due to countermeasure technology. Moving on, since such UAVs were not fit for their purpose, it was imperative that a party that has spent $2 million on a single UAV gets it repaired and understands as to what the issue is so that it can use it for the Air Force. And the same is essential because there is public interest involved here. If a UAV crashes while it's being used for surveillance or defense purposes, it can lead to transnational claims because the Air Force often deals with often surveils the borders. Moreover, even if there's any if it crashes in any way on a civilian, there's a lot of public interest that is at stake here. Therefore, therefore, it is very important to understand that Article 10 of the BIT clearly makes an exception to protect the public interest. Secondly, it's not just the BIT that gives such an exception. Article 39.3 of the TRIPS agreement, which was cited by my opposing counsels, also gives such an exception to the government of Vindeva, and it clearly states that to protect such data against disclosure, except where necessary to protect the public, or unless steps are taken to ensure that the data is protected against unfair commercial use. So, the council has clearly established as to why the public interest in this matter was pertinent, and secondly, the claimant has not established as to what unfair commercial use has happened of the UAVs that have been given to them. There has been no they have not established as to a specific unfair commercial use being there, and it has been already 1.5 year since there has been a dispute and there has been no unfair commercial use, which goes on to show that the government of Vindeva acted in a bona fide manner and did not cause any unfair losses to the claimants. If the tribunal is satisfied with the submissions with respect to issue 3, the
Just
yeah.
one question, if I may. The claimant's memorial talks about the requirements under the treaty for effectively consultation. What is the respondent's position on why that didn't occur?
I'm sorry, Mr. Arbitrator, could you please repeat the question?
Certainly. As I read it, the memorial for the claimant talks about the need to consult under the requirements of the BIT, and is making the allegation that there was no consultation about handing over their patented material to this third party. I'm interested in your position on that point.
Thank you, Mr. Arbitrator, for the question. Mr. Arbitrator, for your convenience, I would like to refer to page 18 of the moot proposition, which refers to Article 7 of the BIT, which has been strongly relied upon by the opposing counsels. However, it is pertinent to understand as to what Article 7 entails. Article now sequestered now opposing counsel sequestered Article 7.2 and presented it to you. However, it's very important as a general rule of interpretation to understand what is written as a whole under a specific article. Article 7 talks about transparency, and Article 7.1 very clearly states to each party shall, to the extent possible, ensure that its laws, regulations, procedures, and administrative rulings of general application. Therefore, a business or a commercial dealing, or in fact, where the government is getting its after sales services because of the wrongful denial by the claimants, is not covered by this article, as can be seen very clearly from this article itself. I Does that satisfy Mr. Arbitrator's question?
That addresses what I was talking about. Yes, thank you.
Yes. Thank you, Mr. Arbitrator. If the tribunal is satisfied with the arguments with respect to issue 3, the council would like to now move on to issue 4. Much obliged. Issue 4 deals with two aspects. The first, that the claimant argues that there has been a breach of the national treatment standard, and secondly, the claimant argues that there has been a breach of the legitimate expectations it holds under the fair and equitable treatment standard. All of these argued with respect to the imposition of indirect tax. Now to break the issue down, the claimant would like to argue that there has been absolutely no the respondent's counsel would like to argue that there has been absolutely no breach of the national treatment standard. With respect to the same, the first argument that is being raised is that the sovereign has a right to tax. It's very important to understand that the sovereign has a right to tax the entities operating in its territory. With respect to the same, the Council would like to submit that the multiple tribunals have specifically emphasized on the state's sovereign right to tax, and that the same establishes a presumption of legitimacy. The same was held in multiple cases of this tribunal itself, being Mobile Exploration versus Argentina, Quasar de Valores versus Russia, and El Paso versus Argentina. Secondly, it has been very specifically established by this tribunal that states do not have a duty to adapt its tax regime to the best interests of the foreign investors. Such cases and such authorities are already existing. Therefore, this is the reason as to why we say that a change in the taxation regime does not prima facie mean that the claimants have a claim against the respondent state. The second argument that the council would like to make is that there was no breach of the national treatment standard, as the regulatory changes in the current circumstance were on account of a legitimate government policy. It is contended that the legitimate to make the same argument, the council would like to refer to page number 30 of the submitted moot proposition, wherein a very important award of this tribunal itself has been cited. In the case of GAMI versus Mexico, it was observed that wherein a reason exists for a measure, it is not itself discriminatory. Therefore, if there is a specific reason and there is a legitimate policy goal at hand, the same cannot be said to be a measure which is discriminatory in nature. Therefore, the basic understanding of national treatment standard is that there has to be a measure which is discriminatory. If it cannot be proved before this tribunal that the measure taken by the government is discriminatory, the government cannot be held liable. The third argument that the respondent would like to make is that no specific promise was made with respect to uniformity of the taxation regime. In the case of Toto versus Lebanon, the aspects of a tax regime change were under consideration. And in the same, it was very clearly held that fair and equitable treatment does not, in the entail a guarantee to the investor that tax laws and custom duties would not be changed. The claimants have failed to provide any specific article or provision under the BIT wherein it has been said that there will be absolutely no change in the taxation regime that is there in the government of Windiva. Therefore, there is absolutely no reason so as to why any relief should be given to the claimants with respect to the same. The second leg of the argument is that the council would like to make is the applicability of the fair and equitable treatment standard in the current case is questionable because because of the simple fact that there has been absolutely no basis given in the BIT wherein the fair and equitable treatment standard has been provided. The point that the council is trying to bring forth is the fact that the parties that are Firel and Windiva, the two states that signed the BIT, very clearly made sure that they wish to adopt the national treatment standard for the protection of the investors' rights and not the fair and equitable treatment standard. It was very categorically stated in the BIT that the national treatment standard is there. Therefore, trying to apply the FET standard is not permissible in the current case. Moving forward, even if, and this is an argument, though, even if the fair and equitable treatment standard is sought to be applied here, the argument that the council would again make is that again there was absolutely no promise made with respect to change in the tax regime. Secondly, the change in question was not unreasonable or drastic, as has been argued on uh, page number 26 and 27 of the submitted memorial. And this has been also very specifically held in the case of AES Solar versus Spain. The Permanent Court of Arbitration, which was a different tribunal, however very persuasive for the current matters, said that it is not sufficient to provide that there has been a change in regulatory framework. It is not sufficient also to provide that the change in regulatory framework is detrimental to the investors' interests. The change has to be unreasonable and drastic. The same was also held by the ICSID tribunal in Impregilo versus Argentina, that the change has to be drastic and unreasonable. For all these reasons, the Respondents' Council likes to argue that the submissions of the claimants with respect to the breach of national treatment or the fair and equitable treatment standard are unfounded and should not be given any heed. If the tribunal is satisfied with such submissions, the council would now like to move on to the submissions with respect to the last issue, that is, with respect to the damages to be awarded.
Before you do that, just a quick word on what's your response to legitimate expectations?
Yes. Firstly, the legitimate expectations are a part of the fair and equitable treatment standard which the council has established do not exist in the current case. That standard of treatment is not applicable to the current case. Even if such expectations are made to be such a standard of treatment is sought to be applied in the current case, the legitimate expectations are unfounded because first and foremost there was no promise made with respect to taxation changes. There is no stabilization clause in the current BIT. Secondly, stability does not mean not evolving. And finally, the final argument that the claimant made was with respect to the fact that the change made has to be unreasonable and drastic, which has not been proven by the claimants, which is not proven by any of the facts in the current case. Therefore, none of the legitimate expectations, if the fair and equitable treatment standard is applied, are breached.
Thank you.
Much obliged, Mr. Arbitrator. Now, with respect to the last issue, the respondent very clearly states that the claimant is not entitled to absolutely any compensation. In the Chorzow factory case, which laid down the principles of as to how an exit tribunal should calculate damages and is the landmark case, it was clearly stated that reparation, as far as possible, must wipe out all consequences of illegal act and re-establish the situation which would have existed if the illegal act had not been committed. However, In the course of the four issues and the arguments in the past 30 odd minutes made by the counsel and my co counsel, it has been clearly shown that there has been no such illegal act for which the respondents must be punished. Secondly, the council would also like to address one of the very specific issues that has been regularly raised by the claimants, which is with respect to the failure of the smart contract and Anubandh. With respect to the same, the claimants regularly argue that the respondent state has somehow misguided them and made them sign a smart contract. However, with respect to the same, the Respondents' Council would like to submit that there is a SEBI framework on Regulatory Sandbox Framework 2020. This is a very specific framework provided, which very clearly says that the applicant shall ensure that before signing up, the user has read all documentation provided and confirm that he or she is aware of risks of using such a solution. Moreover, the reliance on the Indian Contract Act is also unfounded because there are multiple cases under Section 17 of the same that very clearly state, just a second, Mr. Arbitrator, that very clearly state that mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that regard being had to them, it is the duty of the person to keeping silence to speak, or unless his silence is in itself equivalent to speech. Therefore, in a summarized manner, in cases where fraud can be ascertained by due diligence, one cannot claim the defense of fraud. The effort by the respondent by the claimants to say that the respondents have defrauded them can be very easily countered by stating that that the fact that Anubandh was had a regulatory sandbox framework could have been figured out by them very easily. With with the same, the council rests their case and would now like to proceed to the relief requested by the tribunal. Much obliged. In view of the above submissions, the respondent respectfully requests the tribunal to find that the instant dispute is inadmissible for a lack of violation of rights under the BIT and direct the claimant to approach an appropriate adjudicatory body, hold that the damage to the property situated in Mekli was a result of a force majeure event, declare that the respondent is entitled to after sales services with respect to the repairing of the UAVs. Fourth, dismiss the claimant's allegation of the respondent's breach of the national treatment clause with respect to the expiration of the tax exemption, and finally dismiss the claimant's baseless demand of 670 million US dollars in damages. Considering all of these, and the respondents would like to rest their case. Thank you.
Thank you. Right, claimant, are you making a response?
Yes, respected
Respected
arbitrators.
arbitrators, so Team 25 has 7 minutes and 15 seconds left for the rebuttal, and Team 22 has 2 minutes left.
Thank you.
So the timer can start now. Respected arbitrators, firstly, I'd like to mention again that yes, it is a foreign direct investment, and the main purpose of special economic zone is to enhance the FDI. They are investors as per the enterprise definition in the bilateral treaty itself. It has been established in BIT 1.4 through the facts that it has established. This clearly indicates they are investors. And I would like to clearly mention there is no fact that there is this copyright is protected, but the government is claiming that right now. The copyright I like to mention is commercially profiled for that use. The respondent has to pay monetary damages. Copyright is a legal right and more specifically a type of intellectual property protection. And I would like to mention that, respected arbitrators, if you clearly pay attention to this, my learned counsel from the respondent stated that it's a democratic country and peaceful protests will take place. Since the government was aware that peaceful protests may take place, then why were not they were not prepared that that peaceful protest might be converted into violent protest, as he himself gave examples of it. So I would like to prove that they had to provide us full protection and security, as they were well aware that there could have been a protest. And I would like to claim he never said it was a fraud. But they did not consult us before sending the UAVs to another company, because our software, technologies, and everything will be exposed to that. And we have specified this under a copyright, and we hold the patent of this. And testing only few. And I would like to clearly state that my learned counsel said only one collapsed. We had only sent 25 of them, and they were testing it. And it was clearly mentioned because that the UAV could not identify the algorithmic camouflage of the tank and it collapsed. Therefore, it is not our problem to verify it. That's why it has been a confidentiality clause exposure. Now, my co counsel will argue the further points.
Am I audible? Respected arbitrator, firstly, I would like to put forth what was spoken about by counsel number one from the side of the respondents. They spoke about the tax exemption being put forth, which was only applicable from 2019 to 2023, which is clearly hiding of a very essential fact back in 2022, when it was not intimated to my client that this exemption would only last up to 2023. The fact sheet is very clear on the same. It was not intimated. Additionally, when we talk about the same, the head office of my client, that is the Aviron Group, lies in the city of Methali, that is the capital, and also is a part of the special economic zones. When we talk about the special economic zones, everything previously spoken about under issue number 4 comes into play. Thereby, even if the tax exemption, according to the notification sent forth in 2023, comes to an end, we would still be liable to have the same tax exemption, being it located in a special economic zone as per the Custom Tariff Act. Additionally, I would like to move forward and deal with the second point put forth by counsel number one again in the later part of the speech. They said that the case put forth by my friend, specifically the Sri Lankan case, which was a part of a scenario of a war zone in regards to the force majeure events. Now, this is not a war zone, and there's a huge difference between what an war zone is. When we talk about this, we also want to say that the unrest here in this scenario is very predictable, as it was established previously by my co-counsel when she dealt with the same issue. When we talk about this, we also imply that inherently the liability falls on the government, as the unrest was again predictable, as previously the same had happened in different parts of the world, as a generic example of China was put forth. The respondent is liable, as they clearly just ignored the predictability of this unrest, that is that put my client, the Aviron Group's office and its investment into stake. Not just that, it also put forth the whole country at stake. Given the global growth and the international standards, my respected arbitrators, is this what we are looking forward to? Isn't this a risk to world peace when we talk about that? Additionally, I would like to make another point, which actually left me laughing. Council 1, in the initial part of the state from the side of the respondent, stated that the algorithmic camouflage is a countermeasure technology, and they will only be dealing with the effect of the after sale services. Wherein council 2 comes in, and in the very first line of the beginning of the speech states that the algorithmic camouflage is not a countermeasure technology. The council clearly seeks clarification on this same, if the respected arbitrators permit the same. To opinionate on the same, the council would like to clarify that the fact sheet clearly states that all technology used to manufacture the UAVs was provided by the respondent, and only after specific review and a system of checks and balances what they implied. They took into account as the same countermeasure technology is a algorithmic camouflage, is what my client claims, and that is because an algorithmic technology is used only to prevent attacks from the enemy, being it a countermeasure technology, being it qualifying as a countermeasure technology. Therefore, the stand on the same, as presented by my co-counsel and myself, stands. Additionally, we were also there was a question that was put forth by my learned friend in regards to the equitable treatment. Article 1 subclause 6 of the BID, in generic terms, where it defines what law is, states that all laws applicable in as per the international standards and as per this given convention also implies the same. Now, I've given cases in regards to the same previously when I dealt with the issues. Moving forward, in the council number 2, in its respondents claim that my client clearly manipulated them into the smart contract. Anubandh is a company that belongs to the government of Indivia, that is the respondent. The framework was being tested by the government of Indivia, and a 50-50% decision was put into force when the company was employed. In this scenario, the BIT, which is specifically a relationship being bound between two countries when we talk about the same, Firel and Vindivia, making Anubandh the responsibility of the government, and which here is the respondent. The council seeks clarification. Why is this responsibility being denied? Thank you. That is it from my side.
Thank you. Does the respondent wish to use its 2 minutes in rebuttal?
Yes, Mr. Arbitrator, thank you very much. I shall start my time now. Members of the tribunal, at the outset, I would like to clarify that the respondent categorically refutes all the points that have been raised by the claimant today. At the very outset, at the most superficial level, firstly, we would like to say that the present dispute does not include any such concept or idea which is the subject matter of a copyright or a patent. We are not talking about an infringement of any of these intellectual property rights in today's issue, and the claimant's counsels are completely misunderstanding the premise on which this dispute is occurring. Secondly, I would like to address the question of the protests in Mechley and their foreseeability. The council would like to clarify that the cases of AAPL versus Sri Lanka and all the other cases that were mentioned in the course of my argument were to differentiate those cases from the case at hand. In those cases, the force majeure exception was not held to be not applicable because those countries were already war-torn in nature. In the present case, however, Mechley is already civil society. Going there, it is not prone to violence, and therefore there was no reason for the government to constantly stay on high alert. Protests that happen are given police escorts, but police escorts cannot stop a violent mob. Next thing I'd like to say is with reference to the point that was raised regarding the temporal scope of the issue relating to the taxation policy. Here, as was previously stated, because there was no stabilization clause under the BIT, the claimant is not entitled to expect that these laws will not change. And as my co-counsel very correctly pointed out, there was no reason for the government to not make these decisions in the interest of administrating its own country. I thank you for your time. I wish you all have a nice day.
Respected
Thank you.
arbitrator, since we have 30 seconds left, I'll just like to clarify one point my learned co-counsel said as why we are talking about copyrights and confidentiality clause, because they had sent the UAVs to an indigenous company. That's why all the damages and the loss of technology and everything, that's why we are referring to the copyright issues. And as far as Anubandh is concerned, it was controlled by the central bank, and all the regulations were done by central bank, which the mere fact was concealed to us. Therefore, we are referring these points to the respondents to clarify. And that's it. a respected arbitrator. Those were our submissions.
Thank you.
Uh, Mr. Can I request the arbitral tribunal for 15 to 20 seconds of their time to just clarify on the copyright issue, if you permit?
No, I understand time is up, and I think we are clear on the point. Thank you.
Thank you, Mr. Arbitrator.
Thank you so much for the wonderful round. So, if the judges now permit, we can start with the oral feedback.
Who wants to go first?
Why don't you go first, Paul? Yeah.
All right. Well, look, everybody, congratulations on that. It was a very enjoyable moot. They are always difficult to be a participant in, and I know you've probably been pretty busy over the last few days working your way through the rounds. But the fact that you have tested these arguments on both sides, is starting to show in the quality of what you are addressing. So, from my perspective, really enjoyable to be a part of. And some general observations. I was very impressed with the way that you worked through, what was some quite reasonably detailed memorials in the time that we had available. Always, and perhaps this is all about sort of building for the future. Always make sure that you are checking in with the arbitrators that of where you are moving to, and cross-referencing where you sit on your memorials, so that we aren't getting lost. Because if I've gone off and looked at a document that somebody's talked about and I'm looking there, I want to be able to come back into the submissions and very quickly pick up where we are and which phase we are at, because I might have been writing notes, etc. And always look to what the arbitrators are doing for feedback. So if they are conferring, if they have both got their heads down in something, slow it down. Even don't be scared of pausing and not feel that you have to fill all of the spaces with conversation, because what we might be conferring on or noting or looking at could be an extremely important point for you. And so don't be afraid of sort of using a different pace throughout the life of it, just to work in with what the arbitrators are looking at. Responses to questions. Look, I was really pleased with them, particularly when we have a relatively shallow fact base, so that you run out of actually what's in your fact scenario quite quickly. And a couple of the questions were deliberately, I wanted to know what you were going to fill in the backstory with. So, but don't always assume that, and this is something that people do in court and in arbitration all the time, is don't assume that every question that gets delivered to you is a challenge to what you are saying. A lot of the time, whoever's sitting on the bench or at the head of the arbitration table, or on Zoom as it all is these days, is actually wanting to know, is trying to clarify something in their own thinking. So the questions, always be alive to the questions, because the questions can actually be in your favor. But often when we are counsel, we assume that everything coming at us is a challenge to our submission, a challenge to our point of view, a challenge to our witnesses, and that's certainly not the case. As much, and probably more in arbitration, I think, than in court, you will find a very curious form of questioning coming from the panel when they are trying to work out exactly what has gone on, and often on some very complicated factual scenarios, which is what you see typically in investor state work, always in international work, is these very complicated fact scenarios and experts and counterfactual. So a lot of the questions from the tribunal are, I've got to write an award on this, I better know what I'm talking about. So always be alive to working with either the bench if you're in court, or with the arbitrators, to get the most out of the dialogue, so that you are really getting into an engaged position with them about the questions. Always, use the opportunity of a question from one of the panel to not repeat what you already said 5 times, but to expand upon it. Try to work out what their thinking is. What are they stuck on? Where is that question coming from? So that you can feed back into the process, because the process is, particularly in arbitration, I say this, more than court, the process is to get all the information out on the table so that the right sort of award can be written. And you, as counsel, have a significant role in that, in the way that you deliver your information, the way that you work with the tribunal to put them in the best place to write the award that you think and your client thinks should be written, based upon the catalogue of the facts, the law, etc. So I was very impressed, and I'm always impressed with the level of effort and detail that are put into these things. So yeah, all I'm trying to say is the next level of learning for you is around getting the best out of those arguments, and that's working with the tribunal, working with witnesses when you get to. But in this sort of scenario, really working with the tribunal on teasing out these issues, and getting the most out of your answers, so the tribunal can go, right, what have I got fixed in my head? Those 3 documents are key. These 4 points are key. Got that from their submissions, got that from their answers. Now I can lock that in and move on. All right, thank you very much. But very, very enjoyable. I'm worth getting up for this morning.
Thank you. Thank you so much.
Yeah, very, very well done, guys. It was, I mean, I've had the great fortune of sort of presiding over, an actual court as a civil judge too early on in my career when I started off at 23, and I've had the opportunity of looking at counsels from different jurisdictions and senior counsel and so on, and this was very, very impressive. I could see how you had internalized the facts and the legal issues. I mean, it was clear that you've been living this problem with it up on your bedroom door, and eating, sleeping, living it, and that was clear. But at the same time, you weren't too emotionally invested so as to lose objectivity and become the party yourself, so we could have that trust and credibility in what you were saying, as an officer of the court. So you could distance yourself also. You could also be involved when the need be. You were visualizing and anticipating what is to come up. That's very good. And uh, also, some speakers leverage this beautifully, with how they and Paul also mentioned this, how you use silence. As somebody's beautifully said, that poetry is the clever displacement of silence, and prose is the continuation of noise. So you'd stop at a moment and then let that silence be deafening, and then even if I was looking into a document, I'll stop. Oh, what is the silence about? And I'll look up, and then you will make that impactful point. So that was very, very good. I've seen that comes with a lot of experience, but you guys had sort of mastered that so early on. Again, that engagement with the judges is very, very important, because you're dealing with a human being who's suffering from decision fatigue, who's suffering from lack of glucose in his or her system, having taken too many decisions early on in the day. So yes, that engagement, saying something impactful or not saying anything at all, or sometimes, when we see the arbitrators, sort of when we were doing these arbitrations physically, the arbitrator dozing off, you just drop something on your table to sort of get them to pay attention. So of course, these are the things that you were implementing, and well done. The only thing that I would say is that in a case which has so many legal factual issues, it's very important to stick to the fundamentals, and keep it relatively big picture, because otherwise you get lost in the thicket of facts and details. Some of those details may not be important, like a date may not be important, so you don't say 1st Feb 2019, you say 2019. uh, that was done in most arguments well. What I would say as general feedback is that whenever you're making an argument, make the big argument, then you have to make it good. And if you say these are 4 ways in which I'll make it good, these are the 3 points in which I'll make it good, then you are actually taking the arbitrator along, and there are no surprises for me then, and I'm this is smooth for me, the process of figuring this out for you, and a clear reliance on the controlling legal authority, whatever it may be. It may be a clause, it may be a section, it may be an article, and then the case law. So that gives me comfort that you are not leading me astray as a counsel. You rely on legal foundation, and I can trust you with that. So with enough of this Gyan, very well done. I agree with Paul. This is definitely worth getting up Sunday morning, and all the very best. Thank you.
All the very best to the participants. May the best team win. The arbitrators are requested to stay in. We will end the live. The arbitrators are requested to stay in for some time so that the forms can be filled, the feedback forms. The volunteers can please distribute the feedback forms.
I'd like to thank both arbitrators for taking time out to do this on behalf of Team 22. Thank you so much, sir. Thank you for your feedback.
Thank you.
Very
Same.
welcome.
I would like to take a moment off, and I would like to thank for your inputs as well as taking time out arbitrating us out here and giving your inputs. Once the live is ended, I have a few questions though.